House Speaker Nancy Pelosi is continuing her push for the so-called public option in health care reform.
The robust public option is, in my view, a preferred way to go because it saves the most money, $110 billion. It's not the only way to go, and at the end of the day, we will have a public option in our legislation.
And House Majority Leader Steny Hoyer says a clause in the U.S. Constitution gives Congress the power to order Americans to buy health insurance. Our next guest knows a thing or two about the Constitution and says that's not exactly the case. Constitutional lawyer David Rivkin explains to us this morning. Good morning to you, David. Tell us,
good to be with you.
Is this allowed under the General Welfare Clause, Article 1, Section 8 of the Constitution?
No, it's not. And the problem you have, it's not only that this type of a mandate is not supported by any specific grant of authority to Congress, but if a government can do this, there's no limitations to governmental power. Your government can mandate that you buy health club membership, mental wellness lessons, can even require you to buy a car every couple of years. To underscore, this is a fundamental change in our constitutional architecture. The framers wanted the federal government to be a government of limited and enumerated powers. States were meant to have general police powers. This is an absolutely unprecedented thing.
It is, and the CBO actually says, quote, the government has never required people to buy any good or service as a condition of lawful residence in the U.S. Is there another part of the Constitution that would allow the government to require people to buy health insurance? Is it anywhere in the Constitution?
It's not anywhere in the Constitution. It's not in Article 1. This activity can be done at the state level because it's very important to underscore. People think about the Bill of Rights as the way to protect individual liberty, and the Bill of Rights is important, but the framers' overarching goal was to ensure the diffusion of power, but no single branch of government would have too much power. And vertical separation of power with a lot of authorities residing at the state level, the federal government having few limited enumerated powers is very, very important to our constitutional architecture. This takes us in a direction we never were meant to go.
Okay, to show folks exactly what Steny Hoyer is talking about, here is Article 1, Section 8 of the Constitution. It reads, quote, the Congress shall have power to lay and collect taxes, duties, imposts, and excises to pay the debts and provide for the common defense and general welfare of the United States. But all duties, imposts, and excises shall be uniform throughout the United States. Hoyer also says, Mr. Rivkin, he compares this to the requirement to pay taxes, but paying taxes is in the U.S. Constitution.
This is not a tax, plus taxes are imposed on income from economic activities. Remember, this is not imposed on any activity. The mandate is imposed on you merely because you exist. So this is not a tax.
And so finally, David, what kind of a court battle would this open up if, in fact, this reform is passed and individuals and even states would challenge this law? Could this go all the way to the Supreme Court?
It would definitely go away to the Supreme Court. As soon as it passes, anybody subject to this mandate would be able to go to district court and seek declaratory judgment that this exertion of governmental powers is unconstitutional. It would go to a court of appeals and eventually to the Supreme Court, and I'm very hopeful it will be struck down.
So clearly, once this thing gets out of the Senate and the House, another battle looms. David Rivkin, constitutional lawyer, we appreciate your time this morning.
Good to be with you.
All right, some breaking news this morning out of